Welcome everybody. Today we're talking about personal effects. And Ian, do you want to lead off, because you probably have some pretty good experience on dealing with where things can fall off the rails here.
Well, we'll no doubt play that out a lot. I just wanted to start off with a bit of a solemn comment, just that to note the passing of Justice Glenn Haney last night. Glenn Haney was deeply committed to the estates bar, and a deeply committed lawyer and a judge and a dad and a person that we all have been touched by, and directly and indirectly in this practice area. So it's a very sad day, and he's going to be much missed, and he was way too young. So on that note, it is sort of apropos to talk about planning for personal effects. And I guess my opening comment would just be this, is that, and we'll break this down in much more detail in the next half hour, is that I often will say to my clients that I earn a living fighting over teacups, and don't underestimate the importance of the personal effect planning that you can undertake to avoid contentious aspects. Not just, they're not full on litigation necessarily, but it certainly can bring the temperature up in any estate.
Indeed. So here's the agenda for today. We're going to talk about, what do we need to deal with personal effects specifically? What are some options for dealing with them, and some specific drafting comments. So, there's, I guess, two options, right? That we could, for one thing, not deal with personal effects at all. And in which case, of course, they would be part of the residue. And so if you're dividing the residue, among more than one person, you've got to deal with those personal effects. You have to value them. You have to maximize their value, potentially. You have to be careful about discarding them, because you're getting rid of assets that belong to the residue, and the residuary, the proceeds belong to the residuary beneficiaries. Have you seen that, Ian? Do you come across that very often?
No, it's not typical planning that I see. It's typically carved out, as you've noted in item number 2. But it can occur, and it can bring with it, in the right circumstances, it can make a lot of sense. But it's not, I don't know about you, but it's not typical planning from my experience.
Yeah, and I would recommend against it. You can achieve the same thing by having a separate provision for those personal effects, and then it's protecting the executors in some way. I mean, if it falls into the residue, all bets are off, and it's got to be dealt with on a business basis almost. So let's assume that we are planning to carve them out and have a specific provision in the will. So it seems that I came up with 5. I welcome comments in the chat, but it seems like there's about 5 options here. So, one is to make specific gifts of specific items. And you can do that in the will itself, or by a legal memorandum, and we'll talk about that in a second. The second thing is to say a group of beneficiaries have to agree among themselves on how distribution is going to work. The third option is a discretionary distribution. You give someone authority to divvy up and distribute personal effects. The fourth option, and these aren't necessarily exclusive, right? They can be paired together and alternates, etc. The other is 4 is leaving a letter of wishes, what's called a precatory memorandum, precatory meaning non-binding, leaving a list of what you'd like to happen. And the last is a formal selection process. We'll talk about some options there. Anything jump out at you, Ian, that we've missed here?
No, I think this is a good sort of summary of it.
I knew you were going to say that, so I flipped to the next slide. I was hoping actually you were going to say that. So let's talk about the option where we say, client says, I want to give a specific item to a specific person. So the first issue is, if we're carving out personal effects anyway, so you're using a clause to deal with personal effects, then we need to define what are personal effects. I'm not sure it's the greatest idea to just talk about, my personal effects and not define it. And so we'll talk a little bit later about the drafting around that. But
Yeah,
equally
and just on
important.
that,
Yeah.
sorry, just on that point, that definition becomes very important. There's a real perplexing and sometimes competing case law that things are falling into personal effects that aren't necessarily understood to be in that category, and especially when they've got tremendous value.
Yep, for sure. If you're giving away a specific item, describing that item, obviously crucial, right? My ring, is not going to be good enough. So it's important that there be enough description that that it is easy for the executor, as easy as possible, that the executor can identify this item and that the beneficiary can identify, and that they agree on what that item is. Ian, anything?
I think that comes back to the point above too, and that is being specific and defining the items is crucial. And again, one of the things I try not to overlook is that personal effects may not be driven, and most often aren't driven, by the economic value. So more description of what would see a modest item is actually a good idea when needed.
Yep. Cost of delivery, especially if you've got beneficiaries who might get it and live not in the same jurisdiction as the testator, who's going to pay the costs of that delivery of that item? It might not make much of a difference if it's a book, but if it's a piano, it makes a big difference. Sometimes they say, look, I want to give this ring to my granddaughter, but if she doesn't want it, or when she passed away, I want her to give it to someone else, or keep it in the family, or something like that. Those are really precatory wishes, unless you're going to prepare a formal trust for the ring. And so, I've come across that very often in my practice, where they say, look, I want to give it to my daughter-in-law, but I want to make sure it stays in the family. So she's got to give it to, my granddaughter. Do you have any experience, Ian, any ideas or recommendations?
Oh yeah, you sure see this a lot, and there's it's almost always precatory. These sort of hopes that it'll be passed on to the right generation as it goes along, subsequent to the first recipient. And it is, if it really matters, your suggestion is the only way to do it. And if it doesn't matter, then yes, a precatory wish is a good idea, maybe a note to that effect. But I just think it's, again, coming back to the same thing, it may cost you a little bit more time and energy to do it, and it may be a more modest asset than you would justify the legal fees for the additional work. But if it means a lot to you and you want it to pass on in that way, your suggestion is the only binding way to make it happen.
Yeah, and usually I'm able to talk my clients out of that when I explain, it's a formal trust, like, and now with reporting obligations and everything else, I mean, it's
better be worth it.
The other, it's got to be very, very important to them to do that. But the other issue is that sometimes people say, well, I don't want anything mentioned in my will because I don't want to pay probate tax on my personal effects. Whether you mention them in your will or you don't is not going to determine whether you have to declare their value and whether CRA is going to audit you on that, in my experience. So you have that you still have the obligation. Of course, you could consider using, if you don't want to get into that, you can consider using a secondary will. Even if personal effects are the only assets that you're using it for, it does save the executor some time, relieves them of that obligation to value personal effects. So, I'm a big believer in multiple wills, for that kind of thing.
Yeah, and especially if you use technology and you're producing these documents in an efficient way, throwing together 2-3 wills doesn't add a whole bunch of onerous effort on your part. And it really is a simple way to protect that problem. And it also helps control matters with the government of Ontario as well for the EIR return.
Mm-hmm. So when we talk about a specific gift, it can be done in one of two ways. You can either list the item in the will itself. I give my piano to John, right in the will. Or if it's a long list and you don't want it necessarily in the body of the will, but you still want it to be legally binding. And this is the key. If you want it to be legally binding, then you can do it in a separate document, but there's a rule for it to be legally binding. And that list has to be in existence prior to signing the will, okay? And the will has to identify it. By definition, in that situation, you can't then change that memorandum after the fact. It is as if it was in the will. It's just like a codicil, or it's just like as if it was in the will, and you'd have to do it formally, change it formally. If you're going to, if your client wants to amend it. So if the purpose of using a memorandum is, well, I want to change it down the road, this doesn't work. You've got to submit the memorandum. It's part of the will. So when you go for probate, it's included in the will. So Ian, any comments with that?
Yeah, well, just that it's your will needs to refer to the memorandum.
Yes.
And it takes away some of the effort and some of the potential mistakes that can happen, or the misdescriptions that can happen, because the memorandum can be more long form, and it's a great tool.
Now, it has to be kept together. It's as important. Like if you then can't find the memorandum, which is the problem, so sometimes I find it gives a false sense of options to the testator, who thinks, oh yeah, I'll just scratch this out and initial it, when of course it's not the way you do it. So then the next option,
sorry, just on that point though, but from a practical standpoint, you see that a lot. And that really has just converted it into a precatory memorandum in every respect, in the sense that you've amended the memorandum subsequent. So it doesn't meet the test. And the list becomes much more, and often is just precatory, but depending on the nature of the changes you've made.
Yeah, I mean, you might be stuck with the legal binding, and the changes might not be not legally binding. So that's maybe the worst of both worlds. So I typically avoid those, to be honest with you. But the next option is, if you don't want to be bound, if the client isn't, this is so important that this particular item go to this person, there are other options. So one is where you've got a group of people, whether it's children, grandchildren, everyone in the world, if it's a group of people that can be identified, then you could give an option to say, look, as my children, if they're all adults, for example, as my children agree, right? And then we need a default if they don't agree. But I often build that in, that says, look, I'd like you to divide it among my children as they agree, or failing agreement, and then option B, right? That doesn't work so well if you've got minors, or you've got a class that is so large that there's no way you're going to get agreement from everyone. So one has to be careful with that the class or group of people is identifiable, and that you can get their agreement. So number two is, well, let's pick a person, usually it's the executor, to have discretion on how to distribute the assets. And this is often the default in the event that one doesn't work. In other words, there's no agreement, they can't agree. Now then, if they can't agree, then the executor shall distribute it as they see fit. You could also appoint a personal effects, quote, trustee, whose job it is to manage the personal effects and deal with them. That requires some special planning and to think through that option, but it doesn't necessarily have to be the executors. And then the third option is some other method, such as a lottery, or so in other words, there's 5 people and they can't agree. Okay, there's X items that need to be selected. One guy picks first, next person picks second, and they can pick whatever item they want. You can also have bidding wars where an item goes up and the beneficiaries who can't otherwise agree have to bid in sealed bids or whatever mechanism you want to think about. Ian, you have a lot of experience with this, I know. What's your sense on these other methods?
Well, I guess, I mean, one other method I just wanted to mention too is, and I say it half jokingly, but half seen so many times, it's not funny, is the yellow sticky method.
Right.
Uh, so, where the individual's gone around the house and identified them with a note on the back of the chair, sort of thing. Look, as far as I'm concerned, this is, as I say, such a dangerous territory that it's always worth it for me to just make some inquiries with regard to personal assets and don't just sort of slough over it. If there's one Lorne Harris and the rest of it are couches and brown furniture, then we got to deal with the Lorne Harris, and you have to, lottery is not going to work in that situation. It's not, and so those are the sorts of things you want to consider. So it's just one of those things that I try not to rush through in my intake. I want to just take, and it doesn't take long, but just take a few minutes just to make sure. And I use that example often. I'll say, okay, is there an outstanding personal property item that's going to get caught into this system? And if so, how do we best deal with it? Because do you want the rich guy only to win it, and that kind of thing?
Yeah. And I had that exact situation where it was going to go by lottery. Okay. And so they were, yeah, it's going to go by lottery. And for some reason, and this was before eState, but for some reason, it clicked in my head. I wonder if they have a particular item that's worth a lot more than anything else. And they did. And I'm thinking, well, I know which item the first kid's going to pick if we don't do something to discourage that in some way. And so, a couple things, you could direct the sale of that valuable item if you don't want anybody to get it. You can say, and this is really the point 4 here. What about, great, you want to take that most expensive item? No problem. You have to, in essence, buy it from the estate at fair market value. And that way, if you want it, that's fine, but it's coming out of your share of the estate. And that keeps everybody honest, because absent that, that it's quite likely that the first pick is going to be the most expensive item. And that might not be what the client wants. So the idea that, who's going to get the first pick, maybe some sort of random selection for who gets first pick, like you pick numbers out of a hat or something. And then you can rotate, and then the next person picks, and the next person, and then you can rotate that option, or you can, but the big one really is whether, and this is what I always ask them, whether the value of those items should be equalized.
And I will say too, though, is the problem is, that illustration, of course, is important. And that's, like you say, you saved their bacon in terms of catching it on that situation. But it's sort of akin to picking Raptors tickets or Leaf tickets. The guy who gets, the person who gets the Pittsburgh game, because they always, they got lucky enough to pick first, is maybe that's Pittsburgh. I'll pick as an example. You see Sidney Crosby. That's the one game you wanted to see or something. There's a perceived advantage, even if the value isn't that significantly different. So it's the starting point of the process that I want to emphasize. And sometimes what I like to include, and I know eState has this, where you can, like you say, you pick the picking process before you identify who goes first. And it just makes it so much more, it just takes this, look, you want to take the wind out of the sail, because I can tell you the wind is flapping away when you're sitting around the table.
And when clients tell me, well, I want my eldest to pick first, and I want them to do it in birth order. I have my own thoughts. What are your thoughts on that? I do.
Well, I mean, I think that you should just have a little section for therapy, because it's, birth order is the curse of most of my files. So yes, we have to be a little careful. And so when you highlight it in a will, right, it's going to be like, oh, you've always thought he was the best because he was firstborn.
Right. Right.
And I'm third born, so I'm cursed.
I was going to say, we all know where you stood with Rodney.
Down the pecking order.
Right. So those are those sorts of things that if you're doing a lottery or selection approach. But one thing that I want to turn to is the discretionary division, which is, I think, probably the most common, where you give discretion often to the executor, divided among my children, divided among anyone, if you want, in whatever, use your discretion to get rid of my personal effects. So we often, in that case, give some sort of precatory guidance to the executor. And the classic ones are, take into account the wishes of the beneficiary. So, canvass people and see if there's overlap. Generally try to treat them, relatively equally. In other words, I'd rather you not give all my items to my firstborn child or my lastborn child or whatever. And the other one that's helpful, and I would almost always include, is, if I do leave a memorandum or a list, I'd like you to consider it. It's not binding, right? Because it's not referenced in the will, and it doesn't exist unamended forever. This idea that it's flexible, you can amend it, change it, whatever the last memorandum that you've done, consider it and take that into account when you're trying to divvy things up. And that's like your stickies on the different items, because I don't think those are legally binding memorandum, but they are, an idea. You could put that in here. Consider any, stickers I leave on items.
No, and it doesn't, again, I try not to be too lighthearted about this when I talk to my clients about it. And I will talk through creative ideas such as this with this kind of drafting language to see if we can really nail it down. Especially if you've tested it and you've sort of got a feeling that this could be a bit of tension here. It's worthwhile. It's an added value. One of the things that we always want to do is differentiate ourselves from the consumer market for will making. And this is certainly another aspect of it, is that this is thoughtful drafting to avoid potentially catastrophic events. And I say that with having had 31 years of catastrophic events go through my fingers.
Yeah. And it's amazing. I just as an example, had a fight over the frozen food in the freezer, like who was getting the food. And so it doesn't take much. And if we can build in some way, I did not build in the food in a lottery system, but it shows you that it doesn't take much to get people who might not get along to fight, especially things that are personal, so sentimental.
I had a bit of a spicy one. The person who died was an alcoholic, and so he had a giant supply of booze, and there was a fight over how we could just divide up the booze and the wine cellar and all that sort of stuff. And so it was interesting, and I took a personal interest in how that division was there.
Did you take that as like a contingency fee on that?
Yeah, I took maybe a bottle of wine or two out of it.
So this might work if the trustee or the executor or the person using the discretion is not the same as the beneficiaries. Sometimes I see this where they say, a failing agreement, my executor shall determine, but but the same people are the executors. So if they didn't agree as beneficiaries, they're not going to agree as executors. That is not, something that's going to work. So we need another mechanism. Right.
And it can be exactly. And it can be a tool for very seriously considering the appointment of a third party executor as well. You can often get a sense of what's going to happen with personal property disputes before death within your own life. And so if you can identify that this will be a point of friction, that might make it sensible to appoint a trust company just on that point alone, so that they're the ones.
Even if you don't want like somebody to make those decisions in respect of just that, even, so I do want to just call up just in our final couple of minutes, the drafting that you might see. And again, personal effects, you'll see if, that there's a definition of personal effects above this, but here are kind of the options, right? So we've got dividing it among my children in such manner as they unanimously agree, or failing agreement, and then we have different options, right? We've also considered the possibility that one of those kids may predecease, in which case we may not want just an agreement of the survivors. We might want the grandchildren or the children of the deceased child to have a say in this as well. Here's the discretionary option in A, and B is this kind of lottery system. And here's just an example, that some of the things you should think about, grouping things together so that not every spoon has to be dealt with. Again, We've got an option for the selection, who gets to go first. And then there's the option about valuation and buying it from the estate, in essence, to equalize the value. That's especially relevant if they're not the same as the residuary beneficiaries, right? Provision if they're, children of a deceased child, we build that in. And then the idea that, items nobody might want them. So you, executor, you can sell them, you can discard them, you can donate them. And it's your decision, so that the residuary beneficiaries don't get into saying, well, you shouldn't have thrown that out. You should have sold it. You should have gone on eBay. You should have spent, thousands of dollars to recover $500, those kinds of things. The cost of who's going to, of delivering the items. Often we have a minors clause. So if eState sees that there are young people who belong to this group, it's going to build in this idea that we can hold those personal effects or deliver to a parent or guardian or whatever, some sort of mechanism you might want to use for younger beneficiaries of personal effects. And then the idea of consideration when there's a group of people, I'd like you to take into account this, this, and this. And so that's sort of the drafting idea. And is there anything, Ian, that in our final couple of minutes that you wanted to?
Yeah, I just had one other point, and this is a practice point that applies to the drafting point, not the time of drafting your will and also the time of administration. And that is, with technology available, it doesn't hurt to put on your iPhone and swoop around the room and show what is there or what isn't there. And coming back to the precatory methodologies, I just had an estate where they, the deceased had done a bunch of videoing around the house and said, listen, so-and-so can have this table if he wants it, and so on. And it was a very effective tool because it was from the heart, obviously. It was something that they saw after death, and it added some real strength to the precatory wishes of the deceased, and it took some of the tension off. Oh, mom always wanted me to have that table. Well, as a matter of fact, here's a video that says that wasn't the case. So yeah, it's just a tool that you might consider. Yeah,
hearing the parents saying that is much, much more powerful than reading it, which, in my experience. And so if it's something that's personal like that, boy, having the parent say it is really helpful.
And this is the one area where the clients they can actively participate in the documenting of it. Nobody's going to say to a lawyer, hey, listen, I want to draft my minors clause, but they will say, hey, I really wouldn't mind putting a voice to or a face to the name, so to speak, when I want to talk about the personal property. And I've often just said, no problem, save it and send it. I'll keep it on my file.
Yep, you bet. So, yeah, and we've got a couple of questions, and one of them, they seem, about the definition of personal effects, and there's a history to this language. It's been around a long time, but there's still, of course, room for for argument. It's I own more for personal use than for investment. So not my gold bars, they're not my personal effects. But household or garden use or ornament is the old language that we still see from time to time, mostly because there's a lot of case law on what that means. So the other thing that we build in eState is that if there is a dispute as to what thing, the trustees can determine that. And so we don't get into a court application or something to avoid that kind of dispute. Now, you may want that, you may not want that. So, but that's, well, I wanted to thank everybody for being here and watching our presentation on personal effects, which is fraught with potential difficulties. And thank you, Ian, for joining us. And thanks, everyone. I hope you have a great rest of the week, and we'll see you next weekend. Thanks.